6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.
Hey, everybody.
Welcome to the True Crime Squad. I'm Kristi Brower here with my sister, co-host, and partner in crime, Lori Vallow. And Katie Weaver. Hey, Katie.
How's it going?
I'm a little discombobulated, as you could tell, by forgetting to put myself on the screen.
It's clearly the first show of the week. I, too, am... Yeah, I have my cases ready, but I didn't do some of the other essentials that we normally do here until the last second because I just didn't even think about it. But it's because we had a super fun weekend and we're still recovering.
Facts. Absolute facts.
Yeah.
But we did have a fantastic weekend. We went to see Sarah Millican in concert in Salt Lake. British comic. Do yourself a big favor and look her up because she is hilarious. We had so much fun.
We knew we loved her.
I just laughed myself silly at that show.
We knew we loved her. We just didn't know how much.
It is true. It is true. But if you can believe it, we have so much in this show today.
Yes.
But I bet you can tell that we're going to kick things right off with a Lori Vallow hearing. Now, you don't hear us say that very often. We used to say it all the time.
Not anymore. Yeah. So there was a hearing on Friday, and it was yet another restitution hearing, which, believe it or not, we're still not going to be done with those. Poor Judge Bresky.
Right.
But Lori, well, as you can imagine, she was, well, a dick. So without further ado, we're going to blind react it with you guys.
And CR 2022-001242. State of Arizona versus Lori Daybell. Is Miss Daybell on? Is that the Joab Fedorf? Mr. Lum, could I have you turn your camera off just to not be a distraction? All right, I called the case. Let's have a state announce.
Trina Kay on behalf of the state.
And defendant?
Lori Daybell for the defense.
All right, I can hear everyone
For the
fine. This is
defense.
the time set for restitution hearing. Have there been any agreements?
Your Honor, I am not sure. I was going to check with Ms. Daybell if she would stipulate to anything. I do have one correction in the documents on bait stamp 101133. What we've learned is that the gas receipts that were provided are not all of the gas receipts. And so that's why we had done the mileage, but we forgot to remove the gas receipts themselves. So we should actually remove $348.98, which would make the total restitution request $8,600.54.
Okay, I'll ask the defendant, are you stipulating to any restitution?
Your Honor, on Wednesday night, I did receive those Bates numbers that were supposed to be given to me from my advisory council. They mailed them to me. I just got them. I was able to review those. Those ended at Bates number 101161. And yesterday I was informed by my advisory council that the state sent over one more document on Tuesday by email to my advisory council. And I have not seen that document. It's Bates number 101162. It is my understanding, since I talked to my advisory council yesterday, that that document is a document. They kind of explained what it was to me. And so my understanding is, and although I'm aware that counseling, thank you. Although I'm aware that counseling costs can be included in restitution, this document turned over by the state is an Excel spreadsheet totaling $3,147 in counseling. There are no invoices from doctors or insurance companies to my knowledge. So the document in and of itself seems to be insufficient. I haven't actually seen it. However, based on how my trials were conducted.
Because, Kate's just lying about getting counseling.
Well, and like they're going to turn over to her the names of any doctors or counselors that Kay saw. No, they're not. They're not going to give her that information.
Not going to happen.
That's a HIPAA violation, as Lori likes to. She's a big fan of those.
Only when it's for her, though. Let's be real.
Yes. The prosecution and the judge probably have them.
Experience tells me that regardless of what I say or what anybody else says, you're going to order it. I am willing to stipulate today. It is my understanding that I have already been ordered by this court to pay over $534,000 in fees, in fines, surcharges, and court fees. So you can add Ms. Woodcock's total of $12,096.97 of restitution to my tab.
Your Honor, with that correction, it would actually be $11,747.99.
Hold on, 11,740.
$7.99.
All right. Ms. Daybell, you're stipulating to pay restitution to Kay Woodcock in the amount of $11,747.99. Is that correct?
That's correct.
Did any drugs, alcohol, or medication in the last 24 hours that would affect your ability to make this decision?
Have I been on any drugs, Your Honor? Is that what you're asking?
No, I'm asking, have you had any drugs, alcohol, or medication that would affect your ability to understand or make this decision today?
Is Your Honor aware that I am in prison? I have no access to any of those things. So no, the answer is no, I have not.
Thank you for answering the question. Has anyone promised you anything in exchange for your agreement to pay this restitution?
No.
Has anyone forced you, threatened you, or coerced you to get you to agree to pay this restitution?
Only my trials, Your Honor, coerced me.
All right. The court finds that your agreement is knowingly, intelligently, voluntarily made. It's ordered that you pay $11,747.99 in restitution to Kay Woodcock. The restitution would take priority over any other fines and fees that have been imposed. And it's ordered that that restitution be paid out at the maximum rate allowable out of any prison account. Ms. Kay, do you anticipate any other restitution requests?
Your Honor, we are still awaiting restitution requests from Brandon Boudreau. I know that he's been busy with work and he hasn't got all of those documents together. When I get those, I will submit them to.
Look at that smug, rude face. I mean.
And somehow she thinks she's winning here. She just agreed. She has to pay Kay first.
Yeah.
Ms. Daybell's investigator, who seems to be able to get that to her much easier. And just for the record, Ms. Woodcock is still ongoing counseling, so there could be subsequent requests.
Well, the court retains jurisdiction over the matter of restitution for the period that the defendant is serving a sentence. So I'm not setting any further hearings at this time. We'll wait and see if any requests for hearing come in. All right. Thank you. We'll be at recess.
Thank you.
No, Judge. Thank you. What the hell was that?
Wow. I don't know what she thought she was winning there.
I think just
being
the
a bitch?
Yes, ability to be a jerk. Yes. Paula says she thinks she won't have to pay because she'll be exonerated very soon. Jesus,
Right.
Yeah.
Right.
Oh,
Her
and I'm sure she
Jesus.
thinks it's hilarious that Brandon's, on the restitution list because she's always been very jealous of Brandon's money. So,
Yes.
and Kay got all that money. So she doesn't think that she should have to pay restitution to these people because they've already got money. So she shouldn't have to pay restitution for all she did.
Right. I mean, because in her mind, she's done nothing wrong, friends.
Yeah.
With all of these life sentences she has been convicted of and sentenced to. It's pretty wild.
But I do the whole, just put it on my tab. Well, yes, you have quite the tab these days, Lori. That's true.
You sure do.
So that was that. So as you now know, there could be more of these for Brandon, for ongoing counseling for Kay. That I guess she's going to use any opportunity to be an asshole to that judge. So here we are.
Here we are. Well, and I think also Kay is going to use any opportunity she has to get back at Lori.
Yeah.
These are ways she has to get back at her. And I suspect she will use them.
See, I think she needs massage therapy, horseback riding therapy. There's got to be more.
There's got to be more. Dolphin, swimming with the dolphins therapy. Yeah. We could think of all kinds of things that Kay might need after all the shit she's had to go through and all of the time she's has to testify against this bitch in court.
And travel across the country. All of the things.
Yeah. Wow. Boy, that is quite
Kay should receive all the therapies she wants and needs forever for everything that Lori did to her.
She should. She should. That was just pretty wild though, because it makes you wonder, like, what was the judge gonna actually rule?
But of course, he's asking her the questions that he has to ask.
Yeah.
And of course,
Are you
she's a jerk
aware
about
I'm
it.
in prison, Your Honor?
You could be on medication, Lori. Stupid.
You could be on medication. You
And
could
also-
be getting a hold of illegal drugs or alcohol in prison, Lori.
Happens all the time. Yeah.
Yes, it does. Are you aware I'm in prison? Yes. He added some more life sentences to that list to make sure you never get out. Of course he knows. Good God.
Yeah.
Well, that was quite something.
That was something. Painting in France therapy. Ooh, I like that one. Yes. Trips to
Ooh,
Hawaii
yes.
therapy.
Sounds good. Sounds good.
Okay, get out your notebook. We're making you a list.
Cruise around the world therapy? Sure.
Why not?
That too.
Why not? I think a trip to Alaska therapy is called for. And maybe a little jaunt around
let's just
Ireland.
Make sure that Lori has as little commissary money as possible for the rest of her life.
Yeah, I like that too.
Because you know who doesn't get to have snacks the rest of their life? Her children.
Yeah.
And Tammy and Charles. They never get any snacks ever again.
Yeah.
So why should Lori get them?
Yep.
Yeah.
Absolutely. Yeah, right, Natasha. Put it on a t-shirt. Just add it to my tab. That's where we're at now, for sure.
Oh my God, that was wild. That was quite
right.
wild.
See, Jill, that's where I'm at. She's so salty about her having to pay Kay anything because she thinks she already paid Kay $1 million. Yeah.
Right. Yeah. Wow.
You're a bitch, Lori. You are.
Yes, you are.
Yep. All righty. Well, I know that you have a main case for us with Tyler Robinson. So I'm going to let you start that while I try and sort out this hair. I may have to take a quick trip to the mirror.
Okay. So Tyler Robinson and his defense, well, he wasn't actually in court today, but his defense and the prosecution were. They've got a lot of things to hammer out. There is another hearing coming up on the 30th. But today they addressed two things. The first being that Tyler Robinson's defense filed on his behalf a request that he be allowed to wear civilian clothes and be unshackled during all of his hearings from now on.
Wow.
The response that was filed by the prosecution included a response from the sheriff. Now, if that sounds weird to you, it's because it is. The sheriff can't file a response in court.
Well, the does the sheriff in charge of the jail? That may be why,
Well,
because he can
no, it
chime
isn't.
in.
No,
No, he's not.
it is not. No. And the defense had said, this is improper. You can't.
Mm-hmm. Okay.
The sheriff doesn't have any power to file anything in court. Now, as far as a response, as far as security, of course, yes. But just
Okay.
a response from the sheriff himself?
On his opinion of this,
Yeah, no, you can't do that.
but they've done everything a little out of order with this one so far. So
They really have. So the judge ruled on that issue. He ruled on whether or not Tyler can wear street clothes and whether or not he has to be shackled. So those things were ruled upon today. There's more coming up on the 30th because the other thing that they're going to be talking about is whether or not they're requesting a preliminary hearing, and if they are, when is that going to be? But let's go ahead and watch what the judge had to say. I will tell you right now that the way that the judge talks is extremely triggering for me because he speaks like he is speaking from the pulpit in the Mormon church. Any of our ex-Mos or Mormons that are here, you will hear it. It's very strange. I think this man really ought to consider that that apostle cadence is not appropriate for court. And if you are not familiar with that, you wouldn't even know. But for all of us that are, listen to this. It's weird.
We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that
Closed
hearing,
hearings
the parties
already.
addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues, the motion to strike and the motion to appear in civilian clothing and without restraints. Court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party.
Right. So you hear that?
yeah.
This is a request by the defense for civilian clothing and to appear without restraint.
Yeah.
The thing is, the sheriff is not a party in this case. The parties are the state and the defense. The sheriff isn't a party. So it is unusual, and obviously the prosecution will get the security opinions of
Sure.
the jail and all of that stuff. But for the sheriff to just
Weigh in with an
join
opinion
in on this,
Yeah.
no, you can't do that. And you'll see why. The judge will tell you you can't do that.
At the hearing, all agreed that the Sheriff's Department is not a party in this case. The state and the Sheriff's Office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the Sheriff's Department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the Sheriff's Department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the Sheriff's Department by affidavit, declaration, exhibit, or testimony. This order does not limit the Sheriff's Department's ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to request to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the Sheriff's Department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-14 sub 9C of the Utah Rules of Judicial Administration requires that all in custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied. The court directs the Sheriff's Department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
Okay, so yes, those of you who know that cadence is very strange.
Mhm.
He was also reading word for word, and it seemed almost like he had not read it before, which seemed odd. But basically, he agreed that the sheriff cannot respond and file with the court like this. That's not how the law works, which the prosecution well knows. So I find that interesting that they're risking this kind of stuff right from the very beginning. So Tyler Robinson will be allowed to wear civilian clothes, but he will have the least restrictive possible restraints. A couple of things the judge said, he has no criminal history prior. He is innocent until proven guilty, and he has had no behavioral issues in jail.
Mm-hmm.
So all of those things come into play.
Sure.
When it comes to whether or not they have to restrain him or what he wears. The defense actually referenced Brian Koberger in their request, and pointed out the very public nature of Brian Koberger's case, and how important it was to not prejudice the jury pool.
Yeah.
And that's exactly, this is basically the same request.
Yeah.
So some other things that they did not deal with today, but that are going to be dealt with, they're trying to get cameras out of the courtroom in this case. I will say, I think it's interesting that the judge already has put in place a remedy that when Tyler Robinson is restrained, the press cannot film or photograph his restraints.
Yeah.
it is an early indication to me that
Mhm.
this judge is not going to kick cameras out of the courtroom.
Yeah,
Now,
I
he
think
didn't
he's
rule on
not.
that today because they have to actually give time for the press to respond.
Mhm.
And although this request has been made, it has not been, the legal arguments have not been fleshed out. And he's like, you can't just ask for that. Like, you got to tell me why in the
Right.
law,
Mhm.
and then we have to argue it.
Yeah.
And the press will come in with their own attorney, as we've seen before with Daybell, Vallow, Koberger, many
Mhm.
others. The press will come in and argue the right of the people.
Mhm. Yeah.
So it should be interesting to see what happens. But he already put that in place, and I thought, I don't think this judge is going to kick cameras out of the courtroom.
Oh, I don't either. I think the public outcry would be insane over that.
It
I
would.
don't think that's going to be happening. Totally agree with the clothing decision. That was, in my opinion, absolutely the right decision.
Yeah.
And also with of course, he's going to have some restraints. Come on, man. I agree with that too. Shackles, shackles, hello. But
If that was an actual thing,
right?
it'll probably be fairly minimal
Uh-huh.
because he hasn't given them any reason to think that he's going to step out of line. Now, if he gives them a
Right.
reason, that'll change a lot.
If he starts pulling any business on them,
Yes. Yes, then we'll see some different things. Also, we vacated the hearing on the 30th. Not sure why this hearing happened before the 30th. There was a hearing on the 24th. That was a closed hearing. There are a lot of things going on behind closed doors with this case, and I hate that.
Yeah.
I don't like that. I think that
No.
we should be able to see it all. That's the way the legal system is supposed to work.
Yeah.
And then they moved this up because there's been a hearing on Robinson's docket since for the 30th for like a month.
Mm-hmm.
So a little tricky, but they're already switching up days and stuff. So he doesn't actually have another hearing until January 16th because Voluminous has already entered this trial, as we've talked about before. And the defense has said we need time to be ready to consider whether or not we want a preliminary hearing, and then to be ready for one if we do want one.
Right.
So we'll see what happens on January 16th.
Preliminary hearings they have a lot of information usually in them. They are a pretty big deal.
I don't know. I think they should probably waive it. They have a lot.
Mm-hmm.
But we'll see. We'll see how
I would
much
be
they're going to
surprised
attack
if they
the
did
evidence.
it, but
they've made some statements already and filed some things that they're attacking some things, like the text messages and the communications between Tyler and his roommate / girlfriend, because the ones that they have seen don't have any identification on them about who wrote what and at what time and on what day. Now that's all going to come out of a Cellbrite report.
Right.
And what they had given them at this point was screenshots, and those are not evidence. They can't.
Right.
They might be in an arrest warrant, but they are not in court. Like those,
No.
you have to prove this phone and we prove this phone belongs to this person, and that this phone sent this message on this day at this time. This phone that we have proved belongs to this person sent these messages on this day at this time. Like they've got to be able to prove those things.
Right. Right. And the stuff without any timestamps or all of that stuff, they won't fly in court. I mean, that's enough to convict somebody in the court of public opinion, however.
It
and
is.
They were
It is.
leaked real fast, but
in an actual trial, those things have to be verified.
They'll have to come up with something a whole lot better.
So
does the governor have an interest? Yes, he does. Yeah.
Oh, yeah. The governor said that they were seeking the death penalty before he'd even been charged.
Yeah.
It was a bad look. It was a bad look. I think Utah is kind of trying to get themselves under control at this point, because that was a very bad look. It's not up to the governor.
No.
There's a process that states use that has everything to do with the prosecutor's office and the nature of the crime to determine whether or not the case qualifies for the death penalty.
Yeah.
But that is not what happened in this case.
No, that was a real chaotic 24 or 48 hours, more than that. 36 hours,
well,
I guess. But whatever, anyway.
well, and the whole system, they've got to get their shit together because
Yeah.
stuff like that, filing a response from the sheriff as though he had a right to file a response,
Mm-hmm.
those things are violations of someone's civil rights.
Yeah, but does it seem to
And
you, my opinion
you,
is it seems to me so far like that judge is protecting the rights of the defendant. I hope that remains the case.
he is, yeah. In the very first hearing, he sang his own praises for quite a while about how he was going to be sure to do that, which I
Oh,
mean, I would hope so. That is, in fact, your
that's
job, sir.
definitely
Um,
100%. Yeah,
but there have been some things right at the beginning that you're like, you know, you don't want to create reasons for appeal
right.
by doing stupid shit like filing that sheriff's response. That's a
Mm-hmm.
stupid thing. What are you
Yeah.
doing? Like the governor saying, yes, we're seeking the death penalty.
Yeah.
Like releasing Tyler Robinson's mugshot, which is illegal in Utah. They've done
Mm-hmm.
several things at the very beginning of this case that have been dumb.
Right.
So the state's really got to reel it in
Mm-hmm.
and get their
And
shit
the judge
together.
has got to toe a hard line. Yeah, without a
Yeah,
doubt.
and he does. And you can see that is exactly what he's doing here.
Mm-hmm.
He's like, yeah, I can't let you do that. You know I can't let you do that.
Mm-hmm. Yeah.
Yeah.
Good for him. I hope he remains that stalwart. Jamie said in Utah they have leg braces that shock. So perhaps
really?
that's what they'll do with him. Yeah.
That's interesting. And that would not impede him from being able to take notes and participate in his hearings. So I don't know.
Yeah. Well, you know, we watched Lori shuffle in and out of the Fremont County Courthouse how many times in her leg
In her shackles.
Yep.
Yeah, she was in leg irons.
Leg irons.
and-
There you go. Yeah.
And her little Jesus jandals.
Mm-hmm.
Yeah, we watched her come and go that way at Fremont
Yeah.
County many times.
Yep. 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 There was yep, we've seen it happen lots of times and with every prisoner. I mean, that's just pretty normal. But, you know, while he was talking
is.
about whether or not he'd be in street clothes, that was my first thought is if there's a preliminary hearing, he has got to be in street clothes because that will be widely televised if allowed, and
Yeah.
everybody will see him. Yeah.
Absolutely. So
Yep.
pretty interesting stuff. I'm very glad that the insanity around this crime has settled so that we can just talk about it as a high profile murder that occurred without anyone freaking out.
Yeah.
And I think all eyes are on the criminal justice system in Utah right now.
And they should be. Yeah.
Mm-hmm.
Yeah.
Absolutely.
Very good.
So with that, Katie, I know that you have brought for us today a DNA for the win.
Yeah. This actually happened back in April, but it just came across my desk. So I want to talk to you about Julia Sue Wilbanks. Look how beautiful she is.
Mm-hmm.
I'm going to give you a bit of a timeline here. In 1991, on September 23rd, this body, Julia Sue Wilbanks' body, was discovered along Neptune Road near Old Canoe Creek in St. Cloud, Florida.
Okay.
She had been stabbed 17 times,
Oh boy.
including fatal wounds to her heart. And of course, she was deceased when they found her. There was quite a bit of physical evidence as far as blood and hair and other biological samples from the murderer, but they didn't have any suspects identified, and the case went cold really fast. So this is at the very beginning of DNA testing. So they actually did do blood typing and DNA testing, you know, to the best of their ability, but they had nothing. So they interviewed people that knew her and local residents, including men that just lived in the area that had records. No arrests. They couldn't come up with anything. However, they were wise enough to put the biological evidence in a cold locker. And
That's good.
then in the 2000s, There are some advances in DNA profiling, but this case still remains cold. Her family in the 2000s continue to do interviews and continue to, stay in connection with the authorities, but nothing is coming up. And her family's really frustrated because they feel like her case went cold really fast and they just feel like she never really mattered. And I just, I wonder why when you look at the immediate media coverage of this case. Road to drugs leads to early grave.
Oh my God. Victim blaming like that?
Murder victim had criminal record.
Oh, good God.
Julia Sue Willibanks, 27, a prostitute, was found stabbed to death on September 23rd. These are all things I found from newspaper.com.
Good God. That would be exactly why.
I'm not saying that the police just didn't try and didn't think she mattered, but when you look at the kind of press like that, and in some ways I think we're better than this now, but I'm not sure if that's true. I just think it's a good reminder to all of us in the true crime world, don't do that shit.
Right.
Do not blame the victim for their death. This one particularly grabbed me. Road to drugs leads to early grave.
That implies an overdose, not a murder.
Right?
Like,
it
what the
also
hell?
implies that they knew who killed her or why. This is a cold case.
Yeah. That's
So,
gross, man.
This is just making a wide assumption that because she had gotten into drugs, that's why she was murdered. We don't know that.
No.
The police didn't know that. But this is what the press is publishing. Anyway, I just wanted to share those pieces with you guys because what the hell?
Yeah.
So disgusting. And as we know, back especially in the 70s, 80s, and 90s, and still now, if we can label a victim as a prostitute, then, or an addict.
Yeah. Fuck that. They're a victim, period. None of those things mean they deserve to be murdered. No one deserves to be murdered.
Yeah.
Period.
No one, regardless of what they're doing. Yeah. So, keeping going to 2012. So in 2012, the St. Cloud Police Department submits some of that preserved DNA to modern testing. And they are able to put a DNA profile into CODIS, but they find nothing. So her family has continued this all this time, just hoping and hoping beyond hope that something would come from this.
Sure.
Well, in 2024, they pull that DNA back up, and they are able to develop a focused suspect list based on genealogical triangulation. Big surprise. And it points them towards a man named Gene Stuller. This is Gene right here. And from that, they do some observation of Gene, and they see him throw away a drink. And they get the straw, and they take that to a forensic lab, and well, look what we have here.
Wow.
Gene is the man whose DNA was all over Julia Sue.
My God.
So they make an arrest. And his neighbors are shook. They're all like, he's the nicest, friendliest guy. They have no idea.
Aren't they always?
Yeah. Thus far, nothing else has popped up that he could be responsible for, but for some reason, he pinned this young lady down and stabbed her 17 times and killed her. So I'm going to show you the press conference. It is brief, but it's interesting. I really love these police departments that are doing such a good job with their media programs.
Thank you all for being here today. Today marks a significant milestone in the pursuit of justice for a young woman whose life was tragically taken from her more than 3 decades ago. On September 23rd, 1991, the St. Cloud Police Department responded to a homicide near Neptune Road approximately 1/2 mile west of Kissimmee Park Road, now known as Old Canoe Creek Road. There, we discovered the body of 27-year-old Julia Sue Wilbanks, who had been brutally stabbed approximately 17 times, including fatal wounds to her heart. Despite exhaustive investigative efforts at the time, interviews, forensic analysis, and the collection of physical evidence, including male DNA on the victim's clothing, no viable suspects were identified. The case eventually went cold, but it was never forgotten. In 2012, our department committed to solving this case, re-engaged the investigation with the help of DNA Labs International. Through advancement in forensic science and genetic genealogy, we uploaded the suspect's DNA profile into national databases. Over the next several years, genealogical analysis helped us narrow the pool of possible suspects by identifying familial connections. In early 2025, this investigation led us to a primary suspect, Gene A. Stuller, Stuller, a white male born April 23, 1952. Historical records placed Stuller living near Julia Wilbanks' last known residence in Kissimmee at the time of the homicide. In March of this year, our detectives conducted surveillance and successfully obtained a discarded item, a straw containing Stuller's DNA. Subsequent forensic testing confirmed a conclusive match to the male DNA recovered from the victim's clothing. To illustrate the strength of this evidence, it is 1.9 trillion times more likely that the DNA came from Gene A. Stuller than from an unrelated individual. I'll say that again. 1.9 trillion times more likely. Statistically, the probability of a coincidental match was approximately 1 in 930 septillion. With this information, our detectives submitted an arrest warrant, which was signed by the Honorable Judge Eric Dubois. Mr. Stuller has been charged with second-degree murder and disturbing a dead body or associated articles. This case represents not just the power of persistence in science, but the unwavering commitment of this department to honor victims and serve their families, even when justice takes time. To the family of Julia Sue Wilbanks, we recognize your pain, your loss, and your long wait. Today, we take meaningful steps toward closure and accountability. We will continue to stand with you. Let this also serve as a message to our community. The St. Cloud Police Department will never stop seeking justice. Cold cases are never forgotten.
Oh, good on them. Good on the St. Cloud Police Department. Wow.
That's amazing. I know those numbers are so wild. Like,
right. I did dispute
well,
that.
it's definitely him. I mean, what else can you say?
What is a septillion again? Got it. Okay.
Right. Yeah.
Yeah. So he was actually arrested back in April, and this case is just slowly starting to move through the courts. But there will be justice for Julia. So
That's awesome.
So happy for her family and for her. And as always, I have a million questions about these cases. Again, this guy actually did have neighbors that spoke to People magazine that were like, what the hell? We had no idea. Super nice guy. Very friendly, very chatty. So then you have to stop and ask yourself, is this the only one? Could it possibly be? And why? What in the world would the motive for this have been?
Right.
And again, what about close family, friends, children? Like, surely he has other people in his life that were close to him. Are they shocked? Obviously, the neighbors weren't, but are people who know him better? What's he been doing all this time?
Yeah,
just living his life, who wasn't Julia? That's who? Julia.
Right. Well, and just thinking he's gotten away with it. You would think that if someone hasn't been caught for 30 years, that they're pretty sure they're never getting caught. It's got to be a pretty big shock when they are.
Yep.
Wow.
Right? And that's the other question. Did he wait every day for the police come calling at his door? Every time he got pulled over for speeding or past flashing lights, did his heart clench and he wondered if he was next? Or did he think he was just free and clear? Did he really
Right.
think that he was never going to be caught? That absolutely nobody would have ever suspected him and he was good to go?
Yeah.
All questions that I have, but
Exactly. Yeah. It's wild. And you know, the hope is that with the genealogical advancements in DNA, that we're going to have cases that are solved quickly, like Brian Koberger is a great
yes.
example of
Mhm.
a case that didn't go cold, and actually he was
Right.
caught very quickly
Mhm.
because of that
Yeah.
DNA technology. So hopefully,
Yeah.
eventually we'll get to the point where they don't take this long.
Yeah.
At least some of them.
Yep. Absolutely. Right. Good question, Jonna. She said, I wonder how many more are worried right now. I hope
Oh,
so.
it's a lot
Yeah.
of unsolved murders. Oh my God, it's millions and millions.
Well, it is. And I do hope those people see these cases get solved and are quaking in their boots.
Right?
I'm sure some of them are and some aren't. I'm sure some people are absolutely certain that they'll never be caught, and they may not be.
Mhm.
Some of them will die before it ever
Mhm.
happens, you know? I mean,
We've
it
seen
wasn't that
lots of
long
those.
ago. Yeah, it wasn't that long ago. We covered a case where they actually exhumed the presumed killer to do more in-depth DNA work to prove it was them. It happens all the time that the perps have already passed. But I'm glad in this case that he's still alive and has to stand accountable for what he did.
Absolutely.
So,
And that's justice for her family, who has waited for more than 30 years for that.
yeah, yep, absolutely. Yep. So let us always all do better when it comes to victims and their families and speak
Yes.
kindly about them and not act like that.
Yep.
And also, good job, St. Cloud, and great job. I don't know which lab did the genealogy testing. I didn't see that, but if it was Othram or somebody else, good job to you guys too. Amazing.
Absolutely.
Yep.
Definitely.
And that's what I've got.
All righty. Well, that's everything we've got for tonight. We'll be back
Mhm.
tomorrow at 2 p.m. No, at 3 p.m. Mountain on Tuesday.
You're rushing.
And yeah, back at 6 p.m. Mountain on Wednesday and 3 p.m. Mountain on Thursday. So we still have lots more great true crime content. So stick with us. And you know it. We are the True Crime Squad. Thanks for being here.
Take care.
Season 6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.